Welcome, everyone. We're going to give folks a couple more minutes to join, but we're excited to start soon. All right, I'll get us started. Welcome everyone to our final Legal Network for Gender Equity webinar of 2023. I can't believe it's already December. I'm thrilled to have all of you attending today to learn more about our very timely and relevant topic, the new law known as the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. That is a bit of a mouthful, so you will hear us mostly be referring to it as EFSASHA or EFSASHA throughout the webinar today, but we just want to make sure you know what the acronym stands for. So if we haven't met before, if this is maybe the first time that you're tuning in for one of our webinars, I'm Lizzie Vogel. I'm Senior Counsel at the Times of Legal Defense Fund and Legal Network for Gender Equity team here at National Women's Law Center. And before we dig into today's content, I wanted to extend my very sincere thanks to all of you who made today possible. So first, to our attorneys in the legal network, thank you for being here today and for all the work you do on behalf of survivors. Thank you to my colleagues here at the Law Center, Danny Stewart and Jennifer Mondino and Galen Burrows for your help making today happen. And thank you to our fabulous presenters, Julia, Shelby, and Shane, who I will have the pleasure of introducing you all to shortly. A few quick housekeeping notes. As always, the webinar is being recorded, and we will share the recording and slides from today on our website within the next few weeks. And as always, you can find this webinar and all of our past webinars and other resources on our website. And Danny is going to be adding that link to the chat just as a reminder where you can find all of that. All right, next slide, please, Danny. So before I introduce our speakers, I want to give you a quick rundown of what we'll be talking about today. So after introductions, Julia will get us started by providing some background on advocacy about the issue of forced arbitration. Shelby and Shane are then going to discuss some recent cases to provide examples of how EFSASHA has played out in the courts. And then Julia is going to wrap up by talking about next steps about how to expand the protections afforded by this law. And then finally, we'll have lots of time at the end for your questions. So please be thinking about what you may want to ask our very knowledgeable speakers. All right, next, please. So we're really fortunate today to be delving into this topic guided by three true experts on the topic, as they're deeply involved, whether it be on the advocacy side or the litigation side related to EFSASHA. And there are many wonderful things I could say about our speakers today, but I'm going to keep these introductions brief, and you'll see a longer bio for each speaker on the slide. It was also sent by email, but I'll just tell you a tiny tidbit about them now. So first, I'd like to introduce Julia Duncan. Julia is the Senior Director of Government Affairs for the American Association for Justice, located in Washington, D.C. Julia has spent nearly 2 decades advocating for the protection of consumer, survivor, investor, and employment rights. Next, I'd like to introduce Shelby Layton. Shelby is a senior staff attorney in Public Justice's Access to Justice project, where she litigates high-impact cases with the goal of making the civil court system a fair, equitable, and effective tool for those with less power. These cases typically involve workers' rights, civil rights, access to courts, and consumer protection. And then finally, I'd like to introduce Shane Sapini. Shane is the founder of Sapini Law, an employee rights trial law firm in New York City. They're currently hiring. Since its founding, Shane has recovered millions of dollars for working people and establish new legal precedent that broadens access to America's judicial system for all victims of sexual harassment and assault. And with that, I'm going to turn it over to Julia to get us started. Thanks so much, you all.
Thank you so much. And thank you, Lizzie. And thank you all for being here. Really appreciate it. There are many people who worked towards the passage of this law, and I can very safely say that we did so with the goal of having this law serve as many survivors as possible in the courts and within their own advocacy and empowerment. And without you all, that wouldn't be possible. We can work towards enacting a new law, which is great, but if no one uses it, it doesn't really matter. So really appreciate the time you're taking to be here. So I'm just going to give a very brief but broad overview of the issue of forced arbitration, because it is not new, but its relevance in how we work and live today has increased, I think, especially in the last 5 or 6 years. The fight to deal with, put limitations on, and in this case, end forced arbitration began about 16 years ago. The first bill to address forced arbitration was introduced, and I have to give him a huge shout out for those of you who see House members, Congressman Hank Johnson of Georgia. He introduced the first bill on forced arbitration back in 2007. And it was when no one knew what it was, no one really understood why legislation would be needed. And he was there, and he really has been an unsung hero, even in the enactment of this bill and in the larger fight to end forced arbitration. He's joined by Senator Blumenthal in the Senate. They both have broader pieces of legislation to deal with forced arbitration in all of its forms. Before I go any further, though, into the substance, I do want to say that there are many organizations, I think some of them are on this call, that led to and work with us on ending forced arbitration. But there's a core group that works on this on a day in, day out basis. And I just wanted to mention them really quick. Of course, there's Public Justice, where Shelby is, who are wonderful, and Public Citizen, and the National Association of Consumer Advocates, and the National Consumer Law Center, and Gupta Wessler, which is an appellate law firm. But their expertise, their guidance, their day in and day out work on these issues really appreciated, and I'm honored to work in coalition with them. So how do we talk about forced arbitration? So I think most folks on this call are practitioners. I'm going to go very brief. But when we say the term forced arbitration, and we'll get to later why language is so important in this fight, but when we talk about forced arbitration, what we really mean is pre-dispute binding arbitration. Pre-dispute meaning someone is bound to an arbitration clause before the bad thing happens. And this is the notion that people cannot waive fundamental legal rights to file a case in court without knowing what's happened to them. So while almost everyone in the American public is subject to forced arbitration, whether it's through their relationship with their credit card company or their student loan provider, or a long-term care or nursing home facility, or their employer, these clauses apply before the bad thing happens. And it is our view that by their very nature, then, it is not a free and voluntary choice to be subject to forced arbitration. And I certainly don't need to tell most of you on this Zoom that I have never met any survivor of sexual assault or sexual harassment that says, oh yes, I envisioned being sexually harassed at work and having absolutely no rights to file a case in court. I knew that that's what this forced arbitration clause meant when I started a job. And that's the very nature of forced arbitration, is that it is presented, it is forced upon someone before the bad thing happens. And then the second inherent characteristic is that there are no other options to file a case in court. You don't have an option of going to court and filing your case. The other characteristics of forced arbitration, which I'm not going to go into because Shane and Shelby will talk about it a lot and are much better suited than I am. But what I always tell people about the process is that it is secret, it is rigged, and it is biased. And I think if you knew nothing else about forced arbitration, knowing that nothing about forced arbitration is public is probably, to me, the worst aspect of forced arbitration. When a company has cases filed against it in court, we can know that. Cases filed in court, as you all know, are public. There is no public filing system for cases in forced arbitration. There is no way to know when there's a pattern and practice of abuse at a specific company if all of those cases are funneled into forced arbitration, because the companies and the arbitrators are the only holders of that data. The other things I wanted to mention is how biased of a system it is, not only because it's the companies or the defendants that choose the arbitration provider, it's also because the arbitrators themselves lack a lot of things that judges do, and also are not in any way diverse. So I wanted to highlight, the American Association for Justice does a number of reports about forced arbitration, and we were able to look at some data actually self-reported by the arbitration companies, as you can see on your screen, to find that the majority of arbitrators, not surprisingly, are white, and the majority of arbitrators are male, and they come from a corporate background. Now, I have been given the very fair point that the federal judiciary is also made up of majority white and male, and that is absolutely true, though the Biden administration is working very, very hard to change that. We're not there yet. The difference, though, is that in court, proceedings are public. Again, we can know when a case is filed in court. We can go to an open courtroom and hear how a judge is treating the plaintiff and defendant, whoever is appearing before her in court. We can go and see that court process and know that. We can read their decisions. We can understand when a judge may be biased, or when a judge perhaps has let their background influence their decision. And we can appeal those decisions in court. None of that is true in forced arbitration, which is why the demographics of arbitrators, their backgrounds, and how they are chosen by the companies matters so much to why this system is so rigged against workers and against consumers. Can we have the next slide? Thank you. So as I was saying, what is the strategy when every company that sells things or employs people in the United States uses forced arbitration in some aspect, and the majority of companies do? How do you go about talking about this system and starting to restore the rights of workers and consumers in the face of this system? And so what the approach has been is that there is a comprehensive piece of legislation called the FAIR Act, or the Forced Arbitration Injustice Repeal Act. That act would restore the rights of all consumers and all workers, all patients, all long-term and nursing home care residents, to decide for themselves whether and when to either file a case in court or be subject to arbitration. As I said, Congressman Johnson has that bill, and has since 2007 introduced that bill in the House. And Senator Blumenthal is the author of that bill, and that bill exists in the Senate. Those bills have been the subject of multiple hearings. The bill has passed the House of Representatives twice, mostly on party lines, although there is some bipartisan support for the FAIR Act. And that is because of its breadth in terms of helping every consumer and every worker, something that the collective community supports and pushes forward and highlights every chance we can. But at the same time we're doing that, we're also looking at certain types of cases and how forced arbitration impacts people with certain types of cases. And so what you also have pending in Congress are what we call the piecemeal approach. So the ending forced arbitration for sexual harassment and assault is just one of those. That is the one that was enacted. But there are currently bills in Congress to deal with forced arbitration as they are presented in higher education. Almost all for-profit colleges use forced arbitration, which is how they entrap many young people in terms of abusive loans. There are bills in Congress to deal with forced arbitration for members of the military, who are also subject to forced arbitration despite having certain rights to protect them. There are bills to deal with race discrimination. Senator Booker is leading that charge in the Senate, and we are very hopeful that when Congress looks at the issue again, they will zero in on race discrimination. And there is a bipartisan bill that would end forced arbitration for age discrimination. So the point of having multiple bills and also the Fair Act, which would restore the rights of all of us, is to be able to talk about how forced arbitration impacts people's rights, to be able to get really specific in ways that, quite frankly, everyone can really understand. And I mean both Democrats and Republicans, when we talk about ways that individuals' rights are denied and are systemically impacted, we can really understand forced arbitration's true impact. So the strategy, again, to talk about how it's everywhere, but to also really talk about the individual cases where it matters. And then we try, at least I try, to empower people who've been impacted to tell their own stories. So you see on the slide a picture of Gretchen Carlson. She has been a hugely important figure in the fight to end forced arbitration and an advocate for safer and more equitable workplaces. When her case against Fox News and Roger Ailes for sexual harassment was subject to forced arbitration, all of a sudden, many people coming from both sides of the aisle could understand in a very direct way how this legally complicated sounding term, arbitration, forced arbitration, really impacts someone's rights. And that's the approach we pushed heavily. Can we have the next slide? So this is the bill that was introduced, now law, and we will refer back to this as we walk through some things that as practitioners and folks in direct services that we would really like you to know, because as I said at the beginning, this law doesn't matter if survivors aren't aware of it and if practitioners don't know how to use it. So we will consistently refer back to it. This is the version that became the public law. You can go back and pull the bill as it was originally introduced, and you can see how the legislation evolved over time to both meet the conversation that was happening in Congress at that time around forced arbitration, and also how the bill carefully and thoughtfully seeks to not end arbitration, but seeks to restore the right of people in this country to decide for themselves what path they would like to choose when seeking justice and accountability after something bad has happened to them. We have the next slide. So as part of the campaign to enact the bill to end forced arbitration for sexual assault and harassment, as I said, the keys were having congressional champions, having really important legislation introduced. But the single most important thing was finding ways for people who had been impacted to tell their own stories. And one of the crucial, if not the crucial moment in this campaign to enact this law was when the House Judiciary Committee issued friendly subpoenas for survivors of sexual assault and harassment, such that they could come testify before Congress about what happened to them and how forced arbitration and non-disclosure agreements robbed them of both their ability to seek justice and accountability, but also their ability and their right to tell people what happened. So many of the survivors had been through forced arbitration, and had been fighting to make it better, but had been doing so very silently. And a friendly subpoena, which allowed them to speak freely, was the moment in time when, again, when faced with real facts and human beings whose lives have been terribly impacted, both Democrats and Republicans agreed that a restoration of rights, even in the face of forced arbitration, would be possible. And so that's why we talk about the bill in this way. And that's why we work so hard to empower and highlight those people that have chosen to speak publicly about what happened. I'm going to stop there on the strategy and legislative point, and I'm happy to answer questions at the end. But I really want you to hear from Shelby and Shane about the characteristics of this new law and how you might utilize those characteristics to best help people who need protection of the law and are choosing to use it. Thanks.
Thanks, Julia. Yeah, so we have this important victory, and then the question is, how do we use it to get justice? So I want to talk about a few aspects of the law and how it's been interpreted in the courts. I wonder, do you mind just going back to the slide that had the text of the statute on it for a second? Awesome. So the key sort of provision is the one that has an A here on the right of the slide. And it talks about how it says no pre-dispute arbitration agreement or pre-dispute joint action waiver shall be valid or enforceable with respect to a case which is filed under federal, tribal, or state law and relates to the sexual assault dispute or the sexual harassment dispute. And then those terms are defined over on the left-hand side of your slide here. So I want to talk first about that language about a case that relates to a sexual assault dispute or sexual harassment dispute, and then I'll talk about the definitions of those terms. So, sorry, can you go to the first slide? And yeah, awesome. So the first thing is that is the question of, okay, so what claims are exempted from arbitration under this law? And as I just read, it says that it applies to the entire case that relates to a sexual harassment dispute. So the first case to look at this question of, okay, so you have a sexual harassment claim, but you also have other types of claims in your case. Does the whole case go to get to be decided in court, or do some of the claims go to arbitration and some of the claims stay in court? What happens? Is this Johnson v. Every Realm case, which was Shane's case, and we filed an amicus brief in support of Shane's client. And the plaintiff here was a Black man who had both sexual harassment claims, race discrimination claims, whistleblower retaliation claims, and I believe pay claims. So some of the claims were, there was a sexual harassment claim, but then there were also claims that are not sexual harassment as, we usually would think of that term. And so the question in that case was, do all of those claims get exempted from arbitration, or do some of them have to go to arbitration still? And what the court held is that because of the use of the word case here, it means that the whole case, including all those other claims, does not have to be arbitrated, even though the other claims are not sexual harassment claims. So that was a really important first ruling on the scope of this law, because it means that, first of all, that cases aren't going to be split up, but second of all, it sort of broadens the scope of the type of cases where you'll be able to proceed in court instead of in arbitration. And the court really just focused on the plain language of the statute and the use of the word case. So then there's a couple of other cases since the Johnson case that I think are a little bit more mixed on this question. I think the Johnson case was the right approach, that the word case means case. And anytime you have a case that includes a sexual harassment claim, that's the end of it. But especially in the Mira case, which also was in the Southern District of New York, like Johnson, in that case, the court, there was a sexual orientation harassment claim that the named plaintiff in a wage case had brought. So in that case, he had both wage claims and sexual orientation harassment claims, and he was bringing the wage claims, but not the sexual orientation harassment claims on behalf of a class of other workers. And so there, the court held that even though it was all part of the same case, it looked at whether the wage claims were sort of sufficiently related to the sexual harassment claims for there to be, for it to sort of be all exempted from arbitration, and it held that they were not. And, this is the quote here where he says, they do not relate in any way to the sexual harassment dispute. I think that's probably wrong, both factually and legally, because, factually, we all know that sexual harassment and wage theft can often go hand in hand, especially in the restaurant industry, which is the context of this, but also because by splitting up these claims, you're really requiring a lot of duplicative work. Like the supervisors involved are the same people, the employee witnesses are the same people, you're going to be deposing the same witnesses in multiple forums. It just doesn't make sense, I think, also as a practical matter to divide them up that way. And then legally, again, I think the Johnson case had the right approach where case means case. You don't have to look at each individual claim and decide whether it's related to the sexual harassment claim. You just have to, as soon as you have a case that involves a sexual harassment dispute, and it otherwise meets the requirements for the claims being joined together in one case, then that's all you need. And so that case it was the opinion of a magistrate judge, and so that is being appealed to the Article 3 judge, and we don't have a decision on that yet. But that's something to watch for, because I think courts I think that's the wrong way for courts to go about interpreting it. And then in the Turner case, it came out with the right result, but again, used more of the approach of Mira, where the court sort of looked, there were a bunch of claims, there was like a disparate treatment, like wrongful termination, sex discrimination claim, in addition to a sexual harassment claim. And then there were also wage claims concerning wages that were not paid out when the person was fired, and a retaliation claim for the reporting the sexual harassment that was related to the termination. And so there, the court did find that the whole case was exempted from arbitration, but it did so by going through each of those claims and analyzing whether it was sufficiently related to the sexual harassment claim. And so again, I think that is probably not the right approach. The right approach is to just any case that includes the sexual harassment claim goes to court. But it does include some, if you're in a court that seems poised to take this approach of deciding whether each claim is sufficiently related, this case does a good job of explaining why claims like retaliation or wage claims can still be related to sexual harassment. So if you're looking for language on that kind of thing, this Turner case is a good place to go for that. So those are kind of the current approaches that courts are taking to this question. But certainly, you know, at a minimum in any court, it's been pretty clearly established that more than just the sexual harassment claim can be exempted from arbitration if you have multiple claims in your case. Can you go on to the next slide, please? So then the question is, what is a sexual harassment dispute? So in the last slide, we talked about how it says a case related to a sexual harassment dispute, but what is a sexual harassment dispute? And so that's defined as a dispute related to conduct alleged to constitute harassment under state, federal, or tribal law. And so again, it's sort of like two layers of related to. So the first thing is it's a case related to a sexual harassment dispute. And the second thing is the dispute is related to conduct alleged to constitute harassment under state and federal law. So what that raises the question of what if you have a case that doesn't involve, for example, a hostile work environment claim, but it involves something that's related to sexual harassment? Can that case be exempted from arbitration? And in the Johnson case, the court suggested that there are claims like that if brought by themselves would still be considered a sexual harassment dispute. And the example the court gave there was retaliation. So I think that's right. So if you imagine a situation where an employee reports harassment against against a coworker, so they weren't subject to the harassment, but then they get fired for reporting the harassment, for example. That person's claim for retaliation, even though there's not a sexual harassment claim in the case, would still be subject to FSASHA because it relates to conduct alleged to constitute harassment under state or federal law. And then I think it's a lot more unsettled what other types of claims might fall under this. I think, you know, you could think of a situation in which there's disparate treatment or equal pay or something that is a part of a larger pattern of harassment. And I could see those claims potentially falling under this. But, you know, I think this is an area that has not been litigated. In the Johnson case, it wasn't raised in the case, so the court sort of talked about it briefly, but didn't go into very much detail, or it wasn't part of the court's holding. So there hasn't, that I'm aware of, been any cases where this has been litigated directly. And I'm interested to see how far we can kind of push this definition of sexual harassment dispute to include other types of claims in, you know, that are at least related to sexual harassment in some way. And then just a note that the definition of sexual assault dispute is narrower than sexual harassment dispute, but it still uses a broad term, and in that case it says involving. So, you know, again, it can be a claim that is not the claim for the non-consensual sexual act or sexual contact, but involves that in some way. So again, I think that could encompass a retaliation claim, although that hasn't been litigated or ruled on by any court thus far. Great, next slide. So then another question that comes up in these cases is the timing of when there's harassment that occurred before FSASHA was enacted. It was enacted on March 3rd, 2022. And the statutory language says that it applies to claims that accrued on or after March 3rd, 2022. And so the question is, in a number of cases has come up, well, what if you have harassment that occurred before that date? And courts have generally applied a continuing violation doctrine to hold that as long as some conduct occurred after March 2022, it's okay that some of the other conduct occurred before March 2022. So in this Olivieri case, the complaint was filed before March 2022, based on harassment that occurred before the complaint was filed. And the court compelled arbitration, but then the plaintiff moved for leave to amend the complaint to allege harassment that had continued, and also raised FSASHA as a defense. And the court allowed that and said that the claims continued to accrue after March 3rd, so FSASHA applied. That case is currently on appeal to the Second Circuit. And then in the Turner case, the complaint alleged a termination that occurred after March 2022, but the harassment started before March 2022. And the complaint was kind of vague about when the harassment stopped. And the court said that the fact that there was the termination and, sort of at least the complaint could be plausibly read to mean that the harassment continued through March, and that was enough to have FSASHA apply. Next slide. So the last issue is a question of when this FSASHA question arises. So in the Johnson case, there was actually a companion case called Yost v. Every Realm. And they sort of provide a good comparison because in Johnson, in both cases, the court went through the plausibility motion to dismiss analysis. And in Johnson, it found that the complaint did state a plausible claim for a sex-based hostile work environment. And so it applied FSASHA, holding that the case related to a sexual harassment dispute. But in Yost, the court, after going through a motion to dismiss analysis, concluded that there wasn't a plausible claim for a sex-based hostile work environment, so didn't apply FSASHA. So instead of just looking at what claims are alleged in the complaint, the court actually went a step further and conducted a full motion to dismiss plausibility, Iqbal Twombly analysis of the claims before deciding whether FSASHA applies. We argued in our amicus brief in those cases that that's the wrong approach, and we would continue to argue in other cases that that is the wrong approach. I think the language conduct alleged to constitute suggests that really the focus should be on just whether you alleged it or didn't allege it, not on whether the allegations are plausible. And in that way, we think it's similar to other types of jurisdictional determinations that courts do, where they just look at the face of the complaint before conducting a plausibility analysis. So like federal question jurisdiction, for example, it's not whether you've, plausibly alleged a federal claim, it's just whether, or a federal question, it's whether there is a federal question presented by the face of your complaint. Similarly, the Class Action Fairness Act, the analysis is focused on the face of the complaint, not which claims ultimately stay in the case. And so I would encourage folks to make those analogies when talking about this. And then we also cited to the legislative history of the act, where there's some good statements about including in the scope of the act cases that allege sexual harassment, but where the sexual harassment claims are not ultimately successful. And I think sexual harassment is a good example of this, because it is such a discretionary fine line between what ends up being considered severe or pervasive and what isn't. And that if your right to arbitration or to be in court is based on that sort of fine line determination, that doesn't make a whole lot of sense. If the goals are to make sure that survivors are being heard and that abuse isn't being swept under the rug. And then finally, we did argue in our amicus brief that even if even if it's just about like what's alleged on the face of the complaint, the court can of course carve out an exception for claims that are truly frivolous or shouldn't be in the complaint at all. So we're not saying that like you just have to say the magic word sexual harassment and you can get out of arbitration, but you know, the claims have to meet the Rule 11 standard and be, you know, pled to that level and not just be totally frivolous. But this is an issue that has only come up in that I know of so far, or had only come up in the Johnson and Yost cases, but it sounds like it came up again recently, and I'm going to turn it over to Shane to talk about that.
Thanks, Shelby. If we can go to the next slide, please. And before I start, I just want to say how excited I am to get to talk about this issue with this audience. I mean, the FAA, this is the first change to the FAA in 100 years. And we all get to be at the forefront of litigating these issues and making that change that happened legislatively a reality for people in their working lives and in the courts. And so I think it's a really big opportunity. And I don't think everyone's awake to it yet on the plaintiff side of the bar, certainly not on the defense bar. I'm running into, and I'll talk about this a little bit later, but I'm running into people who frankly don't even realize that the law exists. And so they're used to just telling people you can't file this case, la-di-da-di-da, and getting away with it. And so I think it's great that we're all coming together to talk about this and learn about what Julia and others have put together as really an amazing law and a first step towards getting rid of forced arbitration entirely. And so, okay, I'll talk about three things briefly here. The first is just to pose a question, hypothetical to everybody. And that is, and this hasn't been answered yet, but under the analysis that, the type of analysis that Shelby just talked about, which is similar to a motion to dismiss analysis, that let's say leads to a complaint not having plausibly pled a sexual harassment or assault dispute, and the case gets sent to arbitration. The claims weren't dismissed with prejudice. They weren't dismissed at all. They were just compelled to arbitration. Now you're in an arbitration venue where the pleading standard is send us a one-sentence statement of your claim, and all of a sudden you're in arbitration with a sexual harassment or a sexual assault dispute again, even though the law says that you're not supposed to be there with that if you don't want to. I don't know what happens in those cases. I haven't run into it yet, but I don't know how you can square the text of the law with that outcome. And it'll be really interesting to see what happens. Okay. And then next I'll talk about this new case, this Niantic case, which I think is really exciting for a number of reasons. And then I'll briefly touch on sort of how you can think about what to expect when alleging sexual harassment and trying to bust through these arbitration agreements with defense counsel or against defendants. So this Niantic case is a state case out of California, and I don't even think that there is a final oral argument transcript available yet. So it really is just a brand new case. There was some reporting on it in the tech press recently. And basically, this complaint is a class action complaint, mostly focused on equal pay violations and equal pay retaliation violations. And I think what sets this lawsuit apart from some of the ones that Shelby was discussing and others is that there isn't overt, or excuse me, there isn't, the plaintiff isn't pleading any sexual overtures in the complaint. So it's sex bias claims. And in this case, in an oral order, the court denied, as far as I understand it, its entirety, defendant's motion to compel arbitration. And I've pulled out this this portion here because I think it's interesting. And it's interesting because I expect there's going to be a major shift away from filing employment cases in federal court and cases involving sexual harassment and sexual assault in federal court in the coming years, especially in states where there is a notice pleading standard. So states like New York, California, and others. why would you submit your client's claims to what is in effect a heightened pleading standard in federal court when you can bust through the arbitration agreement and have your case heard in state court? So where there's not diversity and where there's not a really compelling reason for federal question jurisdiction, I think bringing cases in state court makes a lot of sense that involve sexual assault and sexual harassment. This case is also important because it's a class action. And so there is some, oh, can we go to the next slide, please? There's some discussion of what that means in terms of showings of uniformity between the class representatives and the class members in terms of sexual harassment actually happening to each person. And in this case, the court said that's not a bar here. We can move forward, and then the class analysis will be a separate analysis, but it's not a bar in terms of the motion to compel arbitration. And so it's important. These developments in the law are important. I mean, you don't have to look any farther than a current Supreme Court case. It's SEC versus Jarkissi to see that corporate America cares about its right to have a jury trial in court. When the SEC pursues actions against corporate America, there's a lot of defendants who think that's unfair and they should be able to have a jury trial. I mean, I think on one of the previous slides, Shelby cited to a case, it was a Tesla case. It's no secret that Elon Musk is antagonistic, to say the least, or ambivalent, if we want to be generous, about the SEC enforcement process. But these same people seem fit to just shove kangaroo court arbitration, forced arbitration down their employees and consumers' throats when it serves them. And not to wax poetic too much, but direct services, the plaintiff's bar, we are the bulwark against that, and we have to be confident in fighting back. Access to the courts is not a bad thing. You're not going to get in trouble because you're pushing for your client's access to the courts. That's what the defense bar often wants to say. Well, you're going to get sanctioned. You can't do this. There's an agreement in place. So let's head to the next slide and talk about that a little bit. What you see down here is somewhat of a unicorn. It's pulled from a case where the motion to compel arbitration was denied on EFA grounds, the Niantic case. You didn't see this prior to the passing of this law very much. And there were structural reasons for that. The FAA itself contains a unilateral interlocutory appeal provision that effectively only applies to corporate defendants who lose motions to compel arbitration. So in general, in federal court, this is not going to be new information to most of you, you can't make interlocutory appeals. You can't make an appeal while there's still issues to be decided. The FAA stepped in and said, wait a minute, if you lose on a motion to compel arbitration, that's immediately appealable. Now, if you lose on a motion to compel arbitration and you are the one seeking to enforce the arbitration, that's appealable. But if you're seeking to bust the arbitration agreement and you happen to lose on that, there's no interlocutory appeal on that. So what has that created? It's basically created a death spiral of terrible appellate decisions. There are very few decisions where somebody has an employee or a consumer has lost a motion to compel arbitration such that the corporation won and compelled arbitration. And so there's just very little case law because of the structure of the FAA showing, that the trial court was wrong. The question just never gets asked, so it can't be answered. And on the other side, every single time a defendant loses one of these, they can appeal it, and they do. And it drags out and it drags on. And there's some other questions about whether the case should be stayed, which is a little bit far afield from what we're talking about today. But all of that is to say, I think we should expect that there is going to be a lot of interlocutory appeals on this issue. And so we have to be prepared to band together and fight those. Let's see. And okay, this the last thing I'll mention, and then I think we can get into some question and answer portion. Corporate America, corporate defendants hate this, okay? They hate this. They want control of everything when it comes to being held accountable. But what's interesting, when you talk to defense counsel, I don't know that they hate this law, okay? Corporate defense lawyers, you know, imagine this. You go to law school. Oh, I want to be in court. I want to be a lawyer. I want to be in court. And then you spend your career saying that you're afraid to go to court. You're afraid to go to trial. You don't get any trial experience because your clients hate going to trial. And that's humiliating. That's a humiliating thing to do for a career where you're a lawyer and your whole goal is to avoid being in court. And so I think on a deep level, there's some idea that maybe we should be in court. And then on a practical level, they get to bill, baby, bill. Discovery in court is real. You actually have to turn over documents. You actually have to sit for depositions, unlike in arbitration, where maybe you're lucky if you get one deposition and you get them maybe 6 months after the discovery deadline to send you over, whether it's 4 documents or 4 million documents just to mess with you. In court, there's actually rules, and the judges are really good at enforcing them, especially in federal court in New York. And so this is a license to bill for the defense bar. So it'll be interesting to see how this all shakes out. If I can ever be of help to anybody, please contact me. I love talking about this issue. And if you want to work on these issues, I'm hiring. So reach out to me and send an application. And I think it would be great to start the question and answer period. Oh, excuse me. I jumped the gun here. We're going to go back to Julia's going to cover some very important topics for discussion.
Thanks, Shane. So really quickly, one rhetorical point, one ask, and then any questions you like, and I see some in the chat, which is great. The first rhetorical point is in terms of advocacy. I think that as lawyers, as a community that deeply values access to justice and accountability through the courts, we can collectively speak about the ills of forced arbitration and the ills of corporate America, and that's really important. However, in terms of talking about this with people who are not lawyers or with policymakers, I know some of you are in states perhaps where not in New York or California, and speaking with policymakers in those spaces can be a little bit challenging. And I just want to offer this perspective. And I should say, I learned a lot of these only by failing many, many times before being able to break through in terms of a message around this. I was speaking with a policymaker, doing my best to convince him that forced arbitration is bad and that no worker or consumer has their rights, has a real opportunity to seek justice or have their rights vindicated in forced arbitration, that it just wasn't true. And I should have explained in my first slide, there was a picture of a lightning bolt because we have a report that analyzes thousands and thousands and thousands of closed claims data, showing that consumers and workers are more likely to be struck by lightning, multiple times, by the way, than win anything in forced arbitration. And you will not hear the Chamber of Commerce or corporate America defend it anymore as a system. They cannot defend it anymore as a system. Now they just are going to rely on, as Shane said, sort of power and leverage to keep what they have because they know they have it, which is why they hate this law. And so I said to this person, I said, okay, he said essentially, I don't know if you're right. I don't have time to dive into the data about whether or not court is better for workers and consumers or arbitration is better. I don't have time. And I said, okay, fine. Let's assume everything corporate America tells you about forced arbitration is true. Let's assume for a moment that it's true. Why is it up to corporate America to force it on people? Why isn't it me as an American, as a constituent, as a voter? Should it not be my right to decide what's best for me? If forced arbitration is the best thing ever, as they say it is, then I should get to choose it. And if it's not right for me, or something has happened to me that I feel should be the subject of a case filed in a public court of law, why don't I get to make that decision? And why don't your constituents get to make that decision? This is not a decision and a power that should be vested in corporate America, leaving the rest of us at corporate America's mercy. This decision about whether and when to file a case should be vested in individuals, in consumers and workers to decide for themselves. This isn't about getting rid of all dispute resolution mechanisms, and it's not about getting rid of all arbitration. It is about returning, right? So pre the Supreme Court decisions in 2011, 2012, 2014, pre that time, individuals had this right to decide. We need to restore the right of Americans to decide for themselves whether they want to file a case in court. And that notion is one that resonates. And I would offer to you that it resonates with Democratic voters and it resonates with Republican voters who are very focused, both very focused on individual rights and liberties and options to decide for themselves how to exercise those rights and those liberties. So that's my rhetorical point. And then my one ask. If you are working with someone who either you cannot help because they are subject to a forced arbitration that does not meet the boundaries of this new law, and they are an individual that wants to speak publicly or be involved in advocacy efforts around this issue because it is empowering to them, please reach out to any of us because what we have to do in order to restore rights of all workers and all consumers is tell individual stories, empower individuals to tell their own stories about how forced arbitration has a real life impact. And because, as Shane and Shelby have sort of walked you through how these cases tend to just disappear when people are compelled to forced arbitration, we have to build out that story for policymakers. So please reach out to us. Please forward case examples that you see, news articles. And again, you know, of course, some people don't want to speak publicly, and we absolutely respect that. But to the extent that you're working with individuals who would like to speak publicly, we would like to empower them to do that in places that'll really, really matter. And the last thing I'll say is I get asked this question a lot. What can be done at the state level? What can states do? Not much. It's depressing. As you all know, the preemption doctrine and the breadth and the scope as defined by this Supreme Court of the Federal Arbitration Act leaves states with very little room to do things around forced arbitration. But I will say this, California's disclosure law is by and large one of the only reasons that we know anything about forced arbitration. California has a law that requires arbitration providers doing arbitrations in their state to publicly report certain data. They make it very difficult. They essentially just dump closed claims data on a quarterly basis on a website. They bury it. It's very hard to find. But that's the only reason we know anything. Starting to relieve the secrecy around forced arbitration so that the data and how this is really being used as a weapon by corporate America against workers and consumers can be brought to the forefront is one of the only other ways that we're going to achieve changes in other areas. So that's just an option I offer to you all at the state level, is working on transparency, disclosure on a bipartisan basis to understand more about what's happening behind the veil of forced arbitration can be a really useful thing, and largely, hopefully, not preempted by the Federal Arbitration Act. I am going to stop there and thank you all so much for listening to this point. And now I think we are good on questions, and I will turn it back over to Lizzie.
Thank you all so much. That was incredibly informative, both moments of inspiration and very sobering. And hopefully it sounds, based on the questions that we're already getting, sounds like really resonated with folks who are in the audience. So we're going to take your questions one at a time. Feel free to either add them to the chat or to the Q&A function. And I actually want to start with Laura's question because it did come in the chat first while folks were talking. And the question was, I always think of this law in the context of employment, but does it also apply to consumers? And Shelby, I know that you added a quick answer where you said, yes, it applies to any sexual harassment or sexual assault dispute, but I just wanted to give folks a second if they wanted on the panel, if they wanted to expand on that at all.
I'll just, oh, go ahead.
Nope, go ahead. Julia.
I was just gonna say very briefly, the law does not amend a what we would think of as a workplace statute or Title VII. It amends the Federal Arbitration Act. And because it amends the Federal Arbitration Act and references state definitions of sexual harassment, it applies regardless of place. Now, we often think about it, and it was very much discussed in its legislative history as one being really helpful to employees, but it applies regardless of where sexual assault or harassment occurs. And I think you're right. That's a very important thing that my own constituency of lawyers did not realize. And I think it's a really important point. And as this bill was being discussed, there were other cases that I think are really important to highlight, especially on behalf of the survivors of those cases, the massage envy cases of sexual assault, the cases that are subject to secrecy, but as we all know, sexual harassment, assault, and exploitation happens a lot in the housing context. It happens often at gyms or other types of spas where there's some sort of consumer client relationship where sexual assault and harassment happen, nursing homes where sexual assault occurs. And we're hoping that because this amends the Federal Arbitration Act and not a sort of sector specific law that already exists, that it can be used to help survivors in all of those contexts. That is at least my great hope.
I think that's absolutely right. And I'll just add that one sort of, I think, open question or challenge around those cases is that sometimes there's like less of a one-to-one matchup between like what you would think of as a sexual harassment claim or a sexual assault claim and the types of claims that you're bringing in those cases. So some states, sometimes it's like a housing discrimination law and it's exactly, there is a claim for sexual harassment. But sometimes it's like a tort claim for something that the elements of the tort claim don't involve showing that it's because of sex or that it's sex-based. And so we're definitely interested in strategizing with people or thinking through sort of how to navigate that when there's not a claim in the case that is overtly about sexual harassment or sexual assault.
And one of the ways that I've been thinking about this and trying to work it in where the facts support it is in New York City, at least, has a really good public accommodations law. So public accommodations cases, the kinds of cases that Julia was just mentioning, cases with, like gig economy type independent contractor assault situations. Negligent hiring, I think, is one hook that kind of speaks to Shelby's point about how we can think about causes of action that may be more directly applicable. Even out, I know I just said negligent hiring, but that is, outside of the employment context. We're talking about like if a security guard who's done this before does it to a patron again, things like that. So yeah, I could also speak to Shannon's question, which is, I am working on a case with a blend of issues, including sexual harassment. We have the EEOC right to sue notice. I'm working on the complaint and planning to file on Monday. In these situations, have you filed in court and initiated the arbitration demand in tandem in order to avoid the scenario that if we are compelled to arbitration, the employer will move to dismiss the Title VII claims as untimely? with all the standard disclaimers that I don't know the specifics of this case, and I'm obviously can't, this isn't any kind of legal advice. I have not been filing any arbitration complaints in tandem. I think just from a tactical level, I could see the defense really jumping on that as saying that you've exercised your decision to arbitrate the case. And I haven't run into any issue where someone said, oh, but it took, 4 months to resolve the motion to compel arbitration, and now you've blown the statute of limitations. I haven't run into that issue. Not to say it won't be raised, but I don't know if any other panelists have anything on that.
I agree with that. And I also wanted to flag that usually in like AAA or jams, when you file the arbitration demand, you sort of have to like say that you agreed to arbitration. Like you have to submit the arbitration agreement that is the basis for your demand and the jurisdiction of the AAA. And so I think to Shane's point, it's hard to do that without kind of waiving your arguments against arbitration. And so yeah, I mean, I haven't, defendants always come up with new stuff, but I have not yet seen the argument that it's untimely because you filed it in court rather than arbitration. I have seen the argument that you're violating the agreement or breaching the contract or something like that because you filed in court. But I think, they could argue that regardless of whether you also file an arbitration.
Yeah, and yeah, to piggyback on that, what I've seen more is that they'll kind of counterfile a preemptive arbitration against a client for that breach of contract claim or something like that. And I should also point out in the slide, we don't have to go back to the slide, but in the slide with the text of the legislation, I think it's subsection B. There's the law is wonderfully clear that this is the issue of arbitrability under this law is an issue for the court to decide, even when the arbitration clause purports to delegate those threshold questions to arbitrators. So don't fall for any, defense lawyer gaslighting saying, oh, this has to be decided by the arbitrator. Look, it says it right here in the clause. No, it doesn't. It can be decided in court. It has to be decided in the court.
Thank you both for that. And I would just give one last call for questions in the chat or in the Q&A function. And as we're waiting for any more questions to come in, we have one more, and I'll put this to Julia first, but Shane and Shelby, please chime in if you have any other recommendations. But Lisa asked if you have a sample transparency bill we can bring to our states.
Yes, reach out just shoot me an email after this and we can share language. We'd be thrilled to share language and also talk through, depending on the state, different ideas or strategies. And also, I think there's real value in talking about it regardless of what your state looks like, because one of the things that all people, again, regardless of political affiliation, find deeply offensive about forced arbitration is its secrecy, its confidentiality, that it's a totally private system where there are no published opinions and there are no essentially rights to discovery. And so talking about that as much as possible is a really helpful thing for the broader fight.
Thanks, Julia. And yes, so folks are asking about recordings and slides, and we will be posting, as Danny just put in the chat, we'll be posting a recording and a copy of slides on our website in the next week or so. Danny, do you mind putting the link to where folks can find our recordings and slides? When you have a second, can you add that to the chat? And I also saw that Shane and Shelby added their emails to the chat, and when Danny has a second, because I'm asking her to do multiple things at once. Danny, if you could hit up to the next slide. So those are everyone's contact information. So feel free to write that down or get that from the chat. And I just want to reiterate how appreciative I am of you all offering to provide consultations or just to check in with folks who need to reach out about any of the topics that we discussed today. And Allison, I saw that you mentioned a specific case that you were working on. If you had any specific questions, feel free to raise them in these last few minutes, but also Of course, follow up with Julia, Shane, and or Shelby individually as makes sense. And I'll give sort of one last chance for any specific questions in the chat. And if not, I will wrap us up momentarily. Thanks, Allison, for including that link to the opinion. Well, I think that if questions come in as I'm wrapping this up, Shelby and Shane and Julia have a couple extra minutes, so I will welcome folks to stay on if there is anything else that they want to ask. Oh, and I see a comment from Julie in the Q&A. So in Virginia, we came within one vote of enacting a state bill on transparency/procurement, hoping to try again this year. I don't know, Julia, if you wanted to respond to that at all, but thanks, Julie, for flagging that.
And yeah, any help we can provide, just let us know. Please reach out.
So in these last few minutes, I would ask that folks please take a second to take our survey on today's webinar. You can either get that through the link that Danny has so helpfully added to the chat, or hold your phone up to the QR code. If you are not currently following us on social media, here are different ways to connect with us. If you're not part of the legal network, please consider joining. You can find more about how to do that at the link that is here on the screen. And I just want to say huge thank yous to our fantastic presenters, Julia, Shelby, and Shane. Thank you for all the time you put into preparing for this webinar, into presenting today. And of course, thank you for all the wonderful and critical work you do every day to support survivors. Thank you to those of you in the audience. Thank you for being here. Thank you for engaging with our speakers and all of your thoughtful questions. And again, one last plug to please take our survey. We really do appreciate any feedback that you have and incorporate that into future webinars. And I think I'll ask the speakers maybe to stay on the screen till about 4:15 for 2 more minutes. So if you do have a question, by all means, take the next couple minutes to put it in the chat, but do please reach out to our speakers via email if that would be helpful. So Danny has the screen up again with folks' emails. But I can put them in, yeah, I can put them in also. I can type them in right now if that's helpful for folks to copy and paste. All right, well, I will let everyone go. But thank you again for attending. Thank you to our speakers, and we'll have the recording and slides up within the next week or so. Take care, everyone.
Thanks,
Hi, thanks,
everyone.